Yeah, it's your boy Jay Maz. Good riddance. You know how we do. I'm going to talk about the court of public opinion. One of my pet peeves, one of the things I can't stand that's going on out here. Now, what is the court of public opinion? Well, it refers to using news media to influence public support for one side or the other in a court case. This results in people outside the justice system, people other than the judge or jury, to basically take for one side or the other, and basically try the side that they're against outside of a courtroom.
And the court of public opinion could also be based on what you assume and what you consume. Wait a minute.
Now, in today's society of 100% social media and 24-hour news shows, this is very dangerous practice. And it's being done more and more and is really alarming to the rights of everyone, especially folks that are supposed to be presumed to be innocent until proven guilty in an actual court of law. So let's take a look at this. Trying cases in the court of public opinion. Now, trying cases in the court of public opinion at times is called mob justice. Fitting term, right? Because it really is the 21st century equivalent to a lynch mob. In criminal cases, allowing public opinion to sway against the accused denies them the right to habeas corpus, as well as their right to due process. What is habeas corpus, you ask? Well, I'll tell you. It's a writ which requires that a person cannot be kept in prison unless they have first been brought before a court to determine if it is even legal for them to remain imprisoned. Habeas Corpus Act was passed in 1679 during the reign of Charles II after the English Civil War. It strengthened the ancient and powerful writ which had been featured in English common law since before the Magna Carta. So historically, habeas corpus has been an instrument to safeguard individuals' freedom against arbitrary state actions. What's an arbitrary state action? Kind of like martial law. And basically, martial law in the United States has only really been declared twice. And contrary to popular belief, only Congress has the right to suspend the right of habeas corpus. So what's the other part of that? Due process. What is due process? It's the legal requirement that requires the state to respect all legal rights that are owed to a person. Due process balances the power of law of the land and protects the individual person from it. Now, Joe Blow, Susie Queen, they don't like me, and so they say I'm guilty. So because Joe Blow and Susie Queen are trusted, respected members of the community, and they say I'm guilty, or, they're star TV show personalities and they say I'm guilty, then I must be guilty. Or 1,000 people on Facebook, 2,000 people on Twitter, and CNN say that I'm guilty, so I must be guilty. You dig? And that's where, this gets into mob justice, and it gets into a lynch mob type of mentality. Now, what's arbitration? What's arbitrary? It's subject to the individual will or judgment without restriction, contingent solely upon one's own discretion. The court of public opinion, especially today, is problematic because it oftentimes is a quick knee-jerk reaction without investigation and little to no actual facts that the judgment is based on. So essentially, it's your freaking opinion. Now, when it comes to the legal system, facts are everything. What you feel like or what you think is irrelevant if you cannot prove it on a factual basis. So, with that being said, let's look at the top 5 cases historically in the United States where the U.S. Supreme Court heard the case and made a decision. The 5 historic Supreme Court decisions, if you will. The first one we're going to look at is Marbury versus Madison, 1803. What was Marbury and Madison about? It established the Supreme Court's role as the ultimate arbitrator of the Constitution and established the court's role in determining constitutionality of laws and the executive actions. Now, that last part there, executive actions, is probably no more important throughout history than it is right now under the Trump administration. So basically, this is part of your checks and balance system at work there. And, you know, with this lunatic in office, it's a good thing that the founding fathers put that in place, because, you know, he would just basically rule with an iron fist as a dictator if that was not the case. Case number 2 that we're going to look at here is Griswold versus Connecticut, and this occurred in 1965, and basically the court established the right to privacy under the 9th Amendment to the U.S. Constitution. Now, the court said that basically banning the use of contraceptives violated the right to marital privacy back then. This case served later, as you can guess, as precedent for abortion rights in 1973 in Roe versus Wade decision, as well as Lawrence versus Texas in 2003, which struck down Texas sodomy laws and made same-sex activity legal in every state in the country. So, you know, we would have never had Roe versus Wade. The LBGTQ community would not have hardly any of the rights and protections that they have now if it wasn't for Griswold versus Connecticut first. And so, you know, part of me going through these 5 court cases is to show you what the court decided based on facts and based on the law. And also, I'm going to get into what it possibly would have looked like if, instead of the U.S. Supreme Court deciding these cases on those decisions, what it would have looked like if we would have left it up to the court of public opinion. But I'll do that in just a second. Let's get through the next 3 court cases, historic court cases, before I put that into action here. So, what is the third one? The third one is probably one of the most important ones throughout history to many, many people. And it's one that I've looked at extensively throughout time. And it is Brown versus the Board of Education in 1953. Now, why was this important? Because this decision famously ended racial segregation in public schools. So basically, what the court determined is that segregation in public schools violated the Equal Protection Clause of the 4th Amendment of the Constitution. This decision, as you know, eventually led to and planted the seeds for the civil rights movement. So that one is probably one of the most important ones at that particular time, and also important to future events that would happen in the country's history. The fourth case is one that a lot of people today, social media personalities, YouTubers, Instagrammers, folks who basically make money spewing their opinions on a daily basis, will really want to pay attention to this one, because if it wasn't for this one, a lot of you wouldn't be able to do what you do today. And basically that court case is the New York Times versus Sullivan in 1963. And this established freedom of the press under the First Amendment to the Constitution. In the ruling, the court said public officials could not sue and recover money for liable damages unless they could prove actual malice in false and damaging statements by folks against them. So, like I said, you fake newsers and peddlers on YouTube would be pretty much fucked if it wasn't for this decision, New York Times versus Sullivan. And then the fifth and final one that we're going to look at from the Supreme Court historically is Miranda versus Arizona, which is where your Miranda rights came from if you've ever been detained by the police. And so in 1966, in the Miranda versus Arizona decision, the U.S. Supreme Court said if basically that this ruling is what brought about Miranda rights, as I said, and any criminal suspects detained by the police prior to being questioned must be informed of their constitutional rights to an attorney against self-incrimination. So in other words, basically, you have Miranda rights based on Miranda versus Arizona in 1966. So if you're detained by the police and they want to start questioning you, you have the right to remain silent, and you also have a right to an attorney. So in other words, shut the fuck up and don't tell them shit. So let's get into what I promised, which is the meat of all this, the court of public opinion, and why I tied in these 5 court cases to my argument against the court of public opinion. Like, how does that fit? So why I mentioned these court decisions in the context of talking about the court of public opinion is probably pretty obvious to most of you. And it's simply because I wanted you to consider a few things. What if public opinion at the time of these decisions was allowed to dictate the decisions themselves instead of the actual facts, and instead of the law, and instead of the law and facts being factored into these decisions that the court made? Now, given that all 5 occurred in the 1960s or earlier, if the white ruling class majority was allowed to decide based on public opinion the result of all 5 of these cases, we would likely have a very different outcome from those cases, and that would affect many, many lives, and it would have affected the direction that the country went in, and it may have even affected where we're at currently today. So, can you imagine that? If we didn't have checks and balances to stop Trump today, can you imagine if there was absolutely no right to privacy in the bedroom at all? Without Brown versus Board of Education, the civil rights movement may have never even happened, and civil rights legislation may have never seen the light of day, much less entered the walls of Congress and ultimately was passed. So, what am I saying? Well, obviously racism still exists today, and we haven't reached the mountaintop yet, as Dr. King put it. But can you imagine how much worse and how much further behind the world would be today if public opinion was left to be decided? The question of unsegregation in the schools in 1953. What if New York Times versus Sullivan never happened? What if we were like countries who have a state-ran and state-controlled process instead of a free association of press? What if you didn't have the right to freely associate? What if you didn't have the right to peacefully protest? A lot of the things that you see today wouldn't be able to go on. You wouldn't have no Black Lives Matter. You wouldn't have the civil rights movement, possibly, as I said. You wouldn't have had women protesting for women's suffrage. You wouldn't have had the marches on Washington. None of this stuff would have existed if the right to peacefully protest wasn't protected under that First Amendment. And as I said earlier, if we didn't have free association of press, if everything was censored by the state like it is in other countries, then a lot of you would be in jail or dead instead of being allowed to be free to peddle lies, half-truths, and the propaganda that you all spew on a daily basis on social media. So, finally, I come to this point. If the court of public opinion decided Miranda versus Arizona, at some point, any one of us who think for ourselves and who question the powers that be, who fight the status quo, and who stand up for the rights of the underprivileged, all of us, if we didn't have Miranda versus Arizona, would pretty much be locked up, or worse, hung in the public gallows, on live television. It would go back to the days of a lawless society, survival of the fittest, which basically would mean that a lot of you, because a lot of you are very weak anyways, when it comes to actuality, like you're good at spewing your opinions on the internet, but when it comes to real life situations, you oftentimes have trouble articulating yourself. You have trouble communicating, and you don't know how to move in political and social situations because you do spend all your time on the internet. So if we were back in that survival of the fittest time, a lot of you would be in some serious trouble. So you see, this idea of taking people's opinions, presenting them as if they are actual fact, then sending them all over the world for other like-minded people to jump on the bandwagon and further perpetuate the untrue agenda. Before you know it, the lie itself is told so many times that it becomes credible. And that is the most dangerous thing that can happen to a civilized society. Look no further than the Red Scare era of the U.S., where basically if you were said to be affiliated with or had any connection to a communist party, whether there was proof or no proof, the Hoover F.B.I. was knocking at your door. This is what also allowed the Hoover F.B.I. to establish the whole organization and department that they put together of COINTELPRO. And as we all know, COINTELPRO was able to just spy on pretty much everybody. They were able to take down the Black Panthers because of their propaganda and the things that they spied on. They went after Martin Luther King. We know all this when the files from the COINTELPRO era were released in the 1970s. We know what type of abuse of power took place under the Hoover administration, and we also know what the country looked like during the Red Scare era. And essentially, this whole idea of trying people in the court of public opinion is no different than when we said that people were communists during the Red Scare era. You can look that up for further information, though. So basically, in the long run, the short version of it is this. The court of public opinion is directly eroding our individual and constitutional rights, and it will continue to do so until we don't even have rights left if people are allowed to get away with this and this is left to go unchecked. I, for one, like having some rights, and I'll take my chances in actual court with actual evidence and facts over what people who don't know me, never met me, and have no idea what I am or am not capable of doing are the ones making the decisions to convict me on mere speculation. You can agree with me or you cannot agree with me. That's basically your opinion. You can decide that for yourself. But, I have no problem with that because that's one of the beauties of a free society is being able to make that determination yourself. But the long and short of it is this. If I'm going to tell you to have the opinion that the general public has, I'm just not going to tell you to do that. You could do that on your own if you want. But what I am going to tell you is that the legal process and facts is what I am going to go by. I'm not even going to argue with you in terms of why the court of public opinion makes sense, because it doesn't. It doesn't make sense when compared to actual facts, when compared to due process, when compared to the right of habeas corpus, when compared to being afforded your constitutional rights. So if you're going to simply go with how you feel, or you're going to go with what you think, or you're going to go with what somebody said on the internet, and that's kind of what you think too, so you're just going to roll with it without double checking the facts, without actually looking anything up. You're just going to spew this stuff and say, well, this has to be true, and they must have done it. The whole idea, the catchphrase of where there's smoke, there's fire. Well, there could be 1,000 reasons for why there's smoke. And there could be 1,000 reasons why the smoke started. It doesn't necessarily mean that an arsonist started a fire. You got to do your due diligence. So if you're not going to do your due diligence, then I'm just going to tell you right now, I'm simply going to turn away, walk the other way, and tell you good riddance.